Yes, so Emma Hodgman, I'm a partner in the Sydney office in our disputes group. Dentons is a global firm by most recently, or by headcount in terms of lawyer numbers, I think the largest firm in the world, so we're everywhere.
Fantastic. So there's been a couple of interesting things that have happened in the legal world, and particularly the contract world, with the coming of coronavirus and the pandemic. One of the things that has started to come from a number of my clients is they're starting to ask questions about force majeure and material adverse change clauses and rent adjustments and things like that. So I thought I would see if we could get a little bit of your take on that. What is starting to happen? What are these clauses and why are they important to developers who are out there?
So we're getting a lot of questions around force majeure. One of the problems with a global pandemic is that force majeure applies differently in different jurisdictions throughout the world. In Australia, it's very much a creature of contract. So basically, whether or not the COVID-19 outbreak will result in a force majeure will depend on, firstly, does the contract have a force majeure clause? And if it does have a force majeure clause, whether or not the outbreak falls within the scope of the clause. So some clauses can be expressed quite broadly, for example, to capture anything that's beyond the reasonable control of the parties. And then other clauses might be quite limited in their application and provide a list of events that would be a force majeure. Typical ones are acts of God, acts of war, pandemic, natural disasters like earthquake. So if the first port of call is the contract, is there a force majeure clause there? Does it apply? Generally speaking, if there is a force majeure event, what it means is that the contractual obligations are suspended, but depending on how long the event lasts for, it may give rise to a right to terminate the contract. There is also an obligation to mitigate loss, but the consequence can be ultimately termination of the contract.
And so what is the difference between that and a material adverse change clause, or is there any difference between them?
Well, yeah, there is, although, again, material adverse change it will very much depend on the terms of the contract and the facts and the circumstances of each case. One of the problems with material adverse change is that it's very rarely used, so there's not much law around it. The change has to be, it's quite often you find a material adverse change clause in a lender-borrower contract. The change has to be substantial and it has to be something that impacts the borrower's ability to perform their obligations under the contract. It can't just be something temporary. It's rarely used. I think quite often one of the reasons it's rarely used, I've been doing recoveries work for banks for 25 plus years, and I think I can remember one occasion where it was threatened as opposed to actually used. And that was in a situation where there was no monetary default. But in most situations where a borrower is impacted by something, they go into monetary default. So if the contract's going to be, or if the loan's going to be recovered, then the borrower will typically rely on the monetary default. So it's not something that is often used. It can't be temporary. I mean, one of the problems with COVID-19 is nobody quite knows when this is going to end, and obviously different businesses are impacted in different ways, so it might be shorter term pain for some than others.
And I guess, are you starting to see more of this? Because it's certainly something that a number of the lenders, and in fairness, it may be a difference between the populations we're working with. I think you do quite a bit of work with some of the larger banks, and most of my dealings are with the second tier lenders, with the non-bank lenders who are out there. Most of those groups are starting to look at their portfolios fairly strongly, and they are invoking these clauses frequently to pull back their loan or to demand extra collateral or something like that from their from the borrower. What are you seeing in terms of how it's coming into play sort of in your neck of the woods?
Yeah, so a lot of the work that I do is for the major banks, and they're unlikely to enforce. They're working with the government, and also they've already made announcements about deferments of loans. So I think it's unlikely that we'll see any recovery action from the major banks, certainly in the short term. Yep. But where I do see problems arising is in the second tier, where you might have second tier lenders who are not working with government and less concerned about public profile than some of the major banks. So I think if there's going to be any aggressive conduct from a lender, it's likely to be in that second tier.
And is there anything that the borrowers should really be aware of? I mean, as you say, first port of call is always look at the contract, read your contract, and see what it says. Is there anything else that you would say they should be doing or thinking about?
Yeah, so the problem is everybody's in the same boat. So even though you might have a right to enforce, I think lenders have to ask themselves, is that the best strategy in the circumstances? Because you might be going in and taking control over assets that you then can't sell, or you have to sell for significantly less than what they were worth before this pandemic came about. So I think lenders should be looking at ways of working with borrowers, engaging early, strategic, being commercial, being realistic, rather than just taking the enforcement route. The other thing to remember is there are going to be changes to the insolvency laws, which have been passed or are about to be passed, which previously you could serve a statutory demand on a borrower and they would have 21 days to pay. Now they're given 6 months. So the amount of the demand, it was $2,000. It's now you've got to have a $20,000 debt and they've got 6 months to pay. So even if you want to go down that insolvency route, you're going to be meeting obstacles along the way.
Right. So this is more something that it sounds to me like what you're saying is it's more something that the lenders are going to have to, they're going to have to deal with. So actually, let me admit John, who's coming into this now. John Grimble, how are you?
Very well. Look, you're not going to believe it. An old family friend visited about 40 or 50 minutes ago, and I completely lost track of time. So sorry about that.
Can I tell you that Emma called it? She said, John is skiving. If he comes on and he has a beer in his hand, that will be par for the course. Classic.
So, are we reconvening? Oh, she's here.
I'm here.
We're actually coming to the end. I have to say, Emma has already covered most of the points that we were going to cover with her. So, we'd love to have you, but yeah, we've already covered quite a bit of ground here.
Not unusual for me to be surplus to use. Hey, the one thing, just a nerdy point, probably more on your general stuff now, seeing as we got you on the line. You know those provisions in leases, the damage and destruction provisions?
Yes.
Classic workaround by the real estate industry for force majeure, because that is the one thing that goes to the heart of the lease, obviously, the ability to occupy. So there you have contracting parties typically. Again, just an example of why real estate documents tend not to have force majeure is because they only let it in very limited circumstances, and a good example would be damage and destruction.
Yeah.
Yeah, just a thought. Yeah.
Yeah.
Observation.
Yeah.
Why don't we do this? We'll finish up a little bit the line of discussion that Em and I were having, and then John, I'll actually go and ask you a couple of questions, if that's okay, and I can sort of edit it in the appropriate way. Although I have to say, honestly, people would probably love just watching this whole thing. They love that stuff. So
yeah, it's more interesting.
It's funny because as professionals, we always were trying to sort of edit out the personal stuff. And sort of in, this kind of world, the marketing world, frequently they're like, oh my gosh, the dog came into the picture. That's fantastic. That's my favorite video.
Yeah.
So
yeah.
Anyway, so Emma, you and I were talking about the fact that this is really going to be more on the lenders than the borrowers in terms of what being on the front foot about how they're going to deal with these things, just because enforcing may not get them anything. And in fact, given the market, may put them in a worse position. Is what
yeah, that's right.
All right, well, that's good. Is there anything else in terms of either force majeure as a concept or material adverse change clauses that people should be thinking about, or do you reckon we've sort of given the highlights on that?
Probably, I mean, certainly look at your contract. That's the first port of call. But, you know, contractual rights aside, you know, as I said earlier, I think, you know, ultimately the best strategy might be to just engage on or without prejudice or reserving your rights under the contract. It's very important to reserve your rights because who knows how this is going to pan out. Engaging with your borrowers now and trying to come to a strategic, commercial and a realistic outcome that will work for both parties might ultimately be the best strategy in the circumstances.
It's interesting that you say that because I had I had Paul Zahara from Aussie, which is a non-bank lender, who was on, and he's been in the property game for, you know, donkey's years, and he said exactly the same thing. He said, you know, in these difficult circumstances, everybody sort of gets into the mindset that they're trying to hide bad news, or they don't want to talk about it, or they want to lawyer up and have a fight or whatever. And he said, my experience is that's not where the best outcomes are generated. The best outcomes are generated from, tell me what the problem is early and let's try to make it a joint problem and let's try to work on it, because you and I are attached to the hip, because you have a project that you don't want to lose, and I have a project that I badly want to get back, you know, what I've lent you. And so we have quite a strong alignment, but it relies on goodwill and not people getting into a prisoner's dilemma of, if I say anything, it'll make it worse, and getting into negative outcomes. So that's it's interesting that both you and the lender have said the same thing.
Yeah, I guess the only different thing that I would say from a legal perspective is, you know, make sure you reserve your rights. And providing you're reserving your rights and you're engaging on a without prejudice basis, you can really, you know, talk as freely as you like and try and come up with a workout strategy. But it's an unusual situation in that everybody is in the same position. So that's why I think even more so, it's more important now to be engaging in negotiations and trying to work something out.
Yeah, fantastic. All right, well, thank you so much. I'll turn our attention to John Grimble, who is another partner with Dentons. John, could you give us a little introduction of yourself?
Hi, CT, and thank you for the opportunity to be involved. One of the things that has always interested me is how far apart real estate and doctrines of frustration and concepts of force majeure are. Real estate's obviously been around a long time, and most of the law has been judge-made, and judges tend to own the real estate. So you'll find there's very little flexibility in real estate documents for times when people can't pay, when rents can't be paid. So it really comes down to one thing, and historically, it's when your premises are actually denied you. Now, we're in a situation with COVID where your premises are available to you, but the government in many, many areas is saying that is either prohibited, unwise, would affect your reputation if you were to exercise your rights as a tenant, simply because it would be perceived to be unsafe. So the premises are in fact no good to you, not for a reason related to their destruction, but simply in order to comply with law. So what we, as lawyers from the 70s and 80s, sad to say, would experience were references to things called moratoriums. Now, those things don't exist anymore in leases, in most leases. There used to be a reference to moratorium saying, despite any moratorium, you must continue to pay the rent. Again, it gives you the sense that a lease is typically a very pro-landlord document. Yeah. So that's an example from the real estate area where concepts of force majeure and frustration don't exist in name, but they exist in action, but only in extremely limited circumstances, usually damage and destruction.
John, can I ask you a question? Because it's something that I don't know. You have talked several times about the concept of frustration. And I know what that is with a small f, but I don't know what that is with a big F or in a legal concept. Could you maybe, illustrate that a little bit for us?
Sure. Without giving you a clinical definition, which of course my colleague Emma does and does daily, essentially if a contract right through to its heart is so incapable of performance that it can be considered frustrated, then in certain circumstances, a court might agree, regardless of what the contract says about the way in which it must be upheld or the way in which it must be continued. A court might agree that the fundamental core of the contract in terms of delivery has been lost. That is when a contract is frustrated. Now, there is no guidance within the document as to when frustration arises. It is a doctrine of contract that sits outside contract and over it. So it does affect contracts classically of delivery, and it is it has a huge intersection with force majeure.
So what do you reckon for the owners of the land or of the premises? What do you reckon they should be doing? Is it similar to what Emma said in terms of your best course is probably to, of course, preserve your rights, but at the same time, to engage in a dialogue with the people on the other side of the transaction? Or is it something where you see better results being achieved by aggressive action?
There is almost no circumstance except one where an aggressive action will achieve a better result. Generally speaking, this period, in the context of lease durations, for example, and long licenses, anything where there's an occupancy arrangement which is paid for, and typically those are leases and in exceptions they're licenses. In any of those circumstances, this period of 3 to 6 months, which on best estimates is what we're looking at as the duration of COVID-19, is only a short period by reference to the length of a lease. So the concepts of frustration and force majeure don't sit well with what we've got. Rather, what the Prime Minister says and what the state parliaments will say in the next few days, especially in relation to businesses of having a revenue of less than 50 million, will be imposition of some form of code. Now, this is hard stuff for a government. Formulating a code that deals with all of the circumstances, it would be quite a feat. So what the government has said is that for sub $50 million revenues impacted, they think at around 30% loss of revenue, they will be expecting the code to be adhered to. How the state governments behave in making it law or just a code, remember codes are often not enforceable, but they are there to lead and direct the industry. If the state governments make these codes or part of them into law, then we're looking at effectively the government dealing with the concepts of frustration and force majeure in a way that makes it relevant to COVID and flexible and there to meet the market as it is today. The one instance that I referred to in which it's still advantageous to throw your tenant out is when you actually need those premises perhaps for redevelopment and you've been dying for this tenant to go. Now, the bad news is if that tenant is in straitened and distressed circumstances, as a rule of thumb, you will have great difficulty in doing that if their business is less than 50 million. Today, I would say that's not the case, but within days, we will see something emerge from government.
Man, guys, I have to tell you, this all sounds like a really complex and fast evolving area. So I'm glad that among my friends and acquaintances, I have really high-powered lawyers I can ask these questions or engage as I need to. So thank you guys both for coming on and talking about this. I really, really appreciate it. And is there anything you'd like to leave us with before we go?
Over to you, Emma, first.
Just one comment. I was surprised to read on the weekend, this would be relevant to people who you advise, CT. I would have thought construction would be one industry that would be reasonably immune from this, but there is a downturn in commercial and apartment construction. I think essentially the article that I was reading said it was just because of a lack of consumer confidence, really. So that was a bit of a surprise, not a good one. Hopefully that's short-lived, but was one industry that I thought might scrape through reasonably unscathed.
Yeah, I'll tell you just as by way of sort of feedback, what I have heard is most of the developers, you know, they look forward to a time when COVID-19 is not the pandemic that it is today, and things are more or less back to normal. And real estate, as you guys well know, I mean, is an extremely strong bet in Australia in general. So we haven't had a lot of time periods where that's been a bad asset class to get into. So they're aware of that. The more difficult thing is the lenders, particularly, is that the capital sources have dried up. And unfortunately, some of the things, the uncertainty that's out there in terms of some of the laws that you guys are talking about or some of the codes that are in place, that uncertainty is bad enough. But the fact is that when lenders here, I had a lender say this to me the other day, said, you know, the government's talking about basically suspending bankruptcy. That was a layman sort of, you know, knee-jerk kind of response. But when those guys get that in their head, they just stop lending, right? You know, if I have no tools for getting back the money that I put out there, then I just won't do it. And a lot of them are sort of in that mindset at the moment. So that's really the thing that I see, is not that the developers have lost their animal spirit in terms of building, or that they feel dismayed by a downturn in consumer confidence. It's more that the money guys don't want to, you know, part with their part of it.
Yeah, and that's certainly the insolvency changes that I mentioned earlier. That also applies to bankruptcy. Yeah. So what you used to have 21 days to pay a bankruptcy notice, it's now going to be 6 months.
Yeah.
So yeah, that is a factor, is that recovery options are being delayed. And certainly in this code that the government's supposed to be handing down, if one of the proposals, as I understand it, is that the tenant will get a reduction in rent, which is commensurate with the amount of their downturn in turnover. Whereas with the banks, landlords who've got obligations to their banks, they're not getting any relief in terms of loan repayments, they're just getting them deferred. So it's a bit of a mismatch there as well.
Yeah, indeed, indeed. John, how about you? Anything else you'd like to leave us with?
I guess our focus today has been both on the doctrines and the way in which it has impacted lenders. Lenders will be terribly interested in how developments are affected, and we haven't talked about that, so that's perhaps for another day.
Yeah.
Thanks,
Guys,
CT.
Thank you so much. I really appreciate it. You guys are both quite high-ranking lawyers within your firm, and I know that your time is very valuable. So thank you guys for sharing your insights on this as we talked about fast, evolving, and super complex topic.
Thanks, CT.